The rules of international humanitarian law seek to extend protection to a wide range of persons. The basic distinction drawn has been between combatants and those who are not involved in actual hostilities. The four Geneva Conventions of 1949 for the protection of war victims cover the wounded and sick in land warfare, the wounded, sick and shipwrecked in warfare at sea, prisoners of war and civilians. Common Article 2 provides that the Convention shall apply to all cases of declared war or of any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by them, and to all cases of partial or total occupation of the territory of high contracting party, even if the said occupation meets with no armed resistance. The rules contained in these conventions cannot be renounced by those intended to benefit from them, thus precluding the possibility that the power which has control over them may seek to influence the persons concerned to agree to a mitigation of protection. The first Geneva Convention concerns the wounded and sick on land and emphasizes that members of the armed forces and organized militia, including those accompanying them who are duly authorized, shall be respected and protected in all circumstances. They are to be treated humanly by the party to the conflict into whose power they have fallen on a non-discriminatory basis, and any attempt upon their lives or violence to their person is strictly prohibited. Torture or biological experimentation is forbidden, nor such persons are to be willfully left without medical assistance or care. The wounded and sick of a belligerent who falls into enemy hands are also to be treated as prisoners of war. Further, the parties to a conflict shall take all possible measures to protect the wounded and sick and ensure their adequate care, and to the charge for the dead and prevent their being despoiled. The parties to the conflicts are to record as soon as possible the details of any wounded, sick or dead persons of the adversary party and to transmit them to the other side through particular means. This convention also includes provisions as to medical units and establishment, nothing in particular that these shouldn't be attacked, and deals with the recognized emblem, that is the Red Cross and Red Crescent. The second Geneva Convention concerns the conditions of wounded, sick and shipwrecked members of the armed forces at sea, and is very similar to the first convention. For instance, in its provisions that members of the armed forces and organized militia, including those accompanying them, were duly authorized and cared for on a non-discriminatory basis, and that attempts upon their lives and violence and torture are prohibited. The convention also provides that hospitals, ships may in no circumstances be attacked or captured, but respected and protected. The provisions of these conventions were reaffirmed in and supplemented by Protocol number 1 of 1977, Part 1 and 2, Article 1, Clause 4, for example, supplements Common Article 2 contained in the conventions and provides that the protocol is to apply in armed conflicts in which people are fighting against colonial domination and the alien occupation and against racist regime as enshrined in the UN Charter and the Declaration on Principles of International Law 1970. The Third Geneva Convention of 1949 is concerned with prisoners of war and consist of a comprehensive code centered upon the requirements of human treatment in all circumstances. The definition of prisoners of war in Article 4, however, is of peculiar importance since it has been regarded as the elaboration of combatants' status. It covers members of the armed forces of a party to the conflict as well as members of other militia and volunteer corps, including those of organized resistance movements belonging to a party to the conflict, providing the following conditions are fulfilled. A. Being commanded by a person responsible for his subordinates. B. Having a fixed distinctive sign recognizable at a distance. C. Carrying arms openly. D. Conducting operations in accordance with the laws and customs of war. This article reflected the experience of the Second World War, although the extent to which resistance personnel were covered was constrained by the need to comply with the four conditions. Since 1949, the use of guerrillas spread to the Third World and the decolonization experience. Accordingly, pressure grew to extend the definition of combatant entitled to prisoners of war status to such persons who, as practice demonstrated, rarely complied with the four conditions. States facing guerrilla action, whether the colonial powers or others such as Israel, naturally objected. Article 43 and 44 of Protocol 1 of 1977 provide that combatants are members of the armed forces of party to an international armed conflict. Such armed forces consist of all organized armed units under effective command structure which enforces compliance with the rules of international law applicable in armed conflicts. Article 44, Clause 3 further notes that combatants are obliged to distinguish themselves from the civilian population while they are engaged in an attack or in a military operation preparatory to an attack. When an armed combatant cannot so distinguish himself, the status of combatant may be retained provided that arms are carried openly during each military engagement and during such time as the combatant is visible to the adversary while engaged in a military deployment preceding the launching of an attack. The Fourth Geneva Convention relative to the protection of civilian persons in a time of war forms an important contribution to written international law in the humanitarian domain. It aims at ensuring that even in the midst of hostilities, the dignity of human person, universally acknowledged in principle, shall be respected. However, the General Diplomatic Conference was not called to revise the Fourth Hague Convention. The Civilian Convention of August 12, 1949, as happily expressed in the conference, shall be supplementary to sections 2 and 3 of the said regulations. This has been clearly provided in Article 154 of the Fourth Convention of 1949. This convention is inspired by the eternal principles of that law, which is the foundation and the safeguard of civilization, and is designed to ensure the respect of human personality and dignity by putting beyond reach of attack those rights and liberties which are the essence of its existence. Common Article 3. In the case of armed conflicts not of an international character occurring in the territory of one of the high contracting parties, each party to the conflict shall be bound to apply as a minimum the following provisions. Number 1. Persons taking no active part in the hostilities, including members of the armed forces who have laid down their arms and those placed hors the combatant by sickness, wound, detention, or any other cause, shall in all circumstances be treated humanly without any adverse distinction founded on race, color, religion of faith, sex, birth or wealth, or any other similar criteria. To this end, whatsoever, with respect to the above mentioned persons, the following acts shall remain prohibited at any time and in any place. A. Violence to life and persons, in particular murder of all kinds, mutilation, cruel treatment and torture. B. Taking of hostages. C. Outrages upon personal dignity, in particular humiliating and degrading treatment. D. The passing of sentences and the carrying out of the executions without previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized people. 2. The wounded and sick shall be collected and cared for. An impartial humanitarian body such as the International Committee of the Red Cross may offer its services to the parties to the conflict. The parties to the conflict should further endeavor to bring into force, by means of special agreements, all or part of the other provisions of the present convention. The application of the preceding provision shall not affect the legal status of the parties to the conflict. It should be noted that after 1949, the term Geneva Convention was extended to cover all four conventions instead of merely the first convention. The conference considered that this would constitute an appropriate tribute to the city of Geneva, the headquarters of the EMRC, and also to Switzerland as a whole. All the four Geneva Conventions are important in the context of humanitarian aspects.